All right, let's just dive right into it. Welcome to The Explainer. Today we're tackling a fascinating showdown where the charming, simple, tiny house movement literally collides with massive federal regulations. Now, I know this sounds incredibly niche at first glance, but it actually touches on constitutional law, massive industry implications, and a really fundamental disagreement over what actually makes a house, and, well, what makes a vehicle a vehicle.
Take a look at these innocent-looking structures on wheels. They're actually at the center of a high-stakes jurisdictional dispute right now. On one hand, you've got this booming industry of builders and buyers who just want to innovate and live simply. But on the other hand, you have rigorous transportation laws and building codes that, honestly, were never really designed to overlap. And right now, those two worlds are colliding head-on over a proposed set of rules.
Here is our docket for today. We're going to start with the tiny house dilemma, move through the data plate dispute, look at the accusations of regulatory smuggling, examine the ICC's defense, explore the federal laws and penalties at play, and finally wrap up with the high stakes of property classifications.
So, Section 1. The Tiny House Dilemma, a clash of codes. At the absolute heart of the matter is the proposed ICC/THIA 1215 standard. Basically, this aims to set comprehensive building rules for tiny homes built on trailers, formerly referred to in the documents as small residential units, or SRUs. Now, the intention here makes a lot of sense, right? As these structures explode in popularity, there's a push to standardize how they're built to make sure they're safe, structurally sound, and actually suitable for people to live in. But the specific mechanism chosen to regulate them, well, that has sparked a massive legal debate.
Moving on to Section 2, the data plate dispute. An innocent piece of metal?
So here is the crucial point. This standard requires placing the gross weight of structure on an interior building plate, far away from the exterior chassis. According to Appendix B of the proposed standard, every single unit must have a small residential unit data plate. It lists your standard building info, builder's name, wind load, snow load, seismic categories. But right there in the middle is this requirement to list the gross weight of structure. And the standard specifies that this plate must be placed on the interior of the structure. We're talking tucked away near a distribution panel and a closet, or, somewhat bizarrely, in a cabinet under the kitchen sink.
Which brings us to Section 3, accusations of regulatory smuggling, the Trojan horse.
And this is where things get really heated. The Tiny House Alliance USA actually accuses the standard of regulatory smuggling, essentially bypassing the Department of Transportation's required highway enforcement mechanisms. Janet Thome, the president of the Tiny House Alliance USA, filed a formal complaint arguing that once a structure is permanently mounted to a trailer and moved on public roads, the weight that actually matters is the combined carried weight, which is exclusively regulated by federal transportation law. She argues that just calling it the gross weight of structure on an interior plate doesn't magically change its legal function as a vehicle weight.
Let's look at how this truly builds a conflict. Federal law mandates that vehicle weight be visibly certified on the exterior chassis, while the proposed building standard places weight limits inside a kitchen cabinet. Under federal law, highway-regulated weight has to be established through manufacturer's self-certification. You do this with a VIN-linked certification label and a tire and loading placard physically affixed to the exterior chassis. This is what allows for clear on-the-spot enforcement by transportation authorities. The complaint asserts that the ICC standard entirely omits these required exterior labels, substituting them with that interior building plate and undefined documentation.
Because of this, critics argue the ICC standard creates what's legally known as obstacle preemption. Think of it like a local town trying to rewrite federal highway speed limits with their own confusing stop signs. You just can't replace a uniform federal highway safety system with a fragmented, localized workaround. The Supreme Court has repeatedly rejected state schemes that might share the same goals as federal law, but completely alter the structural means that Congress specifically chose. Ultimately, the argument is you can't prove Department of Transportation compliance using a building plate tucked away in a closet.
But what does the other side say? Section 4, the ICC defense, not a motor vehicle.
In a formal response letter from ICC President Michael Basso dated April 22, 2026, the Council's Board of Directors outright rejected the idea that their standard violates federal transportation law. They reviewed the complaints through their legal counsel and essentially concluded that it is highly unlikely that federal law preempts the requirement in their draft standard.
The ICC maintains that these tiny homes on trailers simply do not qualify as motor vehicles, meaning the federal VIN certification rules cited by critics just don't apply to them.
Mr. Basso states very clearly that the specific federal regulations in Title 49, which dictate the content and location of certification labels, are explicitly written for motor vehicles. Because a modular home with an integrated chassis doesn't meet that strict federal definition, the ICC argues that those specific labeling laws have absolutely no bearing on their building standard.
They also argue the data plate is merely a helpful informational tool for local jurisdictions determining installation suitability, not an unlawful replacement for transportation rules. The ICC's position is that the interior plate is there so local building authorities, often called the authority having jurisdiction, or AHJ, have general information to see if the structure is safe to install on a site. It's also there for emergency responders. Plus, the ICC points out that putting weight information on an interior plate doesn't stop a builder from also putting weight data on the exterior chassis if they want to. In their view, they aren't replacing DOT rules at all. They are just making a building code. Which leads us to Section 5, Federal Law and Penalties, the Supremacy Clause.
To really grasp the stakes here, we have to look at the foundational level, the Supremacy Clause of the Constitution, which dictates that federal law is the ultimate law of the land. The critics of the standard rely heavily on this. Basically, if a federal agency, like the Department of Transportation under the authority of Congress, occupies a regulatory space, a local building standard cannot implement rules that conflict with or obstruct that federal framework. It is literally a cornerstone of the United States legal system.
Under the Motor Vehicle Safety Act, state and local standards must be completely identical to federal standards to be lawful, leaving practically zero room for separate code requirements. Congress placed the creation of motor vehicle safety standards at the federal level to ensure nationwide uniformity at the point of manufacture. By inserting non-identical requirements at the point of fabrication, critics argue that the ICC standard places manufacturers in massive legal jeopardy, essentially forcing them to choose between a local building standard and strict federal compliance.
And to put that jeopardy into perspective, just consider this number: over $139 million. That staggering figure is the maximum civil penalty for a related series of violations under federal motor vehicle safety laws. It really highlights the devastating risk for tiny home builders caught in the middle. The National Highway Traffic Safety Administration does not play around. A single violation can carry a penalty of nearly $28,000, and a separate violation occurs for each and every item or failure to perform a required act. Imagine pouring your life savings into an innovative tiny home business only to face literal financial ruin because you followed local building codes that completely violated federal law.
Finally, Section 6, High Stakes and Classifications, Real versus Personal Property. Federal definitions are incredibly strict here. Real property must be affixed to land, while personal property encompasses everything else, including structures that are currently being fabricated or transported. It's a strict binary system under the Code of Federal Regulations. If it is not attached to the earth, it's personal property. No gray area.
The Tiny House Alliance asserts that by treating these mobile units as real property way too early in their life cycle, the standard deliberately attempts to sidestep federal DOT oversight. The crux of the preemption argument is really one of timeline. The critics say that at fabrication and while rolling down the highway, this unit is unequivocally personal property and therefore entirely subject to federal vehicle and transportation laws. They argue the ICC standard treats the unit like a permanent building, real property, right from the factory floor, effectively skipping over the necessary legal steps for safe highway transport. So I'm going to leave you with this thought. When a home is simultaneously a building and a vehicle, how do we safely govern innovation without breaking federal law? As the tiny house movement continues to innovate, how can regulations evolve to keep up with homes that constantly blur the line between real estate and the open road? We have an incredibly creative industry pushing the boundaries of housing, but they are caught in this massive tug-of-war between standard building codes meant for stationary houses and federal transportation laws meant for highway safety. Finding a legally sound path forward isn't just about cutting red tape, it's about defining the very future of alternative living. Thanks for joining me on this explainer, and I'll catch you next time.